a program by, for, and about women today with Sandra Elkin.
Good evening and welcome to Woman. Tonight we're going to discuss lesbian mothers and the custody of their children. With me tonight is Barbara Handschu, a practicing attorney in Buffalo, New York. Barbara is a member of the National Lawyers Guild. Also with me is Margo Hagaman, a practicing attorney in private practice in San Francisco. Margo is a member of the California Women Lawyers Association. Both attorneys have tried and are familiar with custody cases involving lesbian mothers. Welcome to both of you.
Thank you.
What is the situation exactly with lesbian mothers who are involved in court fights for custody of their children?
Well, Sandy, it's been a fairly recent phenomena, really since 1970, that women that would announce that they were lesbians and go into court and fight for the right to have their children. Prior to that time, there was just a closed case that they would not be granted custody of their own children. In San Jose, at that time, there was a leading case in which a mother did admit in court that she was a lesbian and did receive custody of her 3 children with that on the record. And this was the first time in any court in the country that this took place. There were restrictions, however, on that particular case, and it seems to be the trend in California at least. The restrictions on that case were that she could not live with her lover, and in fact she could not see her lover in the presence of the children. So now in California, we estimate about 50% of the cases could result in the custody with the mother if she does acknowledge that she's a lesbian. However, she can't win everything. She can't at the same time live with her mother. That's what we as attorneys have to tell our clients, not to expect to be able to live with your lover and the children in the same household.
So in a way, the situation has improved because it's out in the open now.
It's improved in that she's getting custody to her own children, but it isn't what everybody would want or expect.
Barbara, according to your experiences, is that pretty much the same? Or?
I think the East Coast is lagging somewhat behind. I know our experience in New York is that many of the cases are not quite as favorable to the mother. I'm quite familiar with several that have taken complete custody from the mother, where she is left with restrictive visitation. She can visit only outside the presence of her lover, which is even more dismal to have to confront a client with if she wishes to acknowledge her sexual preference, that it may well cost her her children.
Is that usual for custody cases, heterosexual custody cases,
No,
those kinds of restrictions?
Our law in heterosexual custody cases has advanced to the point where, in New York State at least, the courts have acknowledged that women and men can have heterosexual relations and still maintain custody. And I have never seen a case that said to a person in a heterosexual relationship, you may have your children but not your lover, or you may not see your children in the presence of your lover. I've never seen that restriction.
Have you, Margo?
In California, it's a trend in that direction also. There are restrictions that the court feels they can place on any home in which it has to award children. So if a woman is living with a man she's not married to, she has the choice of either marrying him or having him move out. And obviously women can't get married under our state law or any state law that I know of. So they feel free to say that this is not a fit home for the children if the 2 adults are involved in a sexual relationship and not married. But it is giving way a little bit in case law.
It appears to me, and granted, you know, I don't know as much about it as you two do, it appears that the fitness of the mother, the lesbian woman, is always a big question. And I wonder, is there any definition of a fit parent?
Traditionally, there's no definition of what constitutes fitness, nor of the other category, which is what's in the best interest of the children. What's, to me, most essential, and I wish would be the primary concern of a court, is whether or not behavior of one person, ordinarily the lesbian mother, has any nexus or connection to her ability to be a good parent to the children. My answer is an emphatic no, that one's sexuality doesn't have that connection to parenting, and that I, in all my experience and my dealing with experts, both experts for fathers who've asserted this and my own experts for mothers who've said there's no connection, I've yet to see a scientific study or anything that could point its fingers and say if one is a lesbian mother, it will have this adverse impact upon the children. That should be, but in terms of definitions of fitness or best interest of children, it's a case-by-case determination. It is a rather subjective determination if you have a case before one judge who is going to determine both what the facts are and what the law is and how to apply them in the best interest of the children.
A lot of the literature that I read, and a lot that I didn't get to read, I know, talks about our homophobic society. And can you talk a little bit about what that means to you as lawyers trying these particular kinds of cases?
Sure. I think Barbara did mention a very important point, that we should look at what the mother's relationship is with the child or children rather than the mother's orientation, whether it's sexual or heterosexual, homosexual or heterosexual. And when it comes to court and it is brought out either by the father of the children, or maybe the mother is in a position where she would like to admit that she is a lesbian, that this is the case, then the judge, it's like throwing up a red flag in the minds of the court, and I think larger society too, that the judge is very fearful at that point of placing the children in a home that might be homosexual in orientation. This is not necessarily based on any evidence that is brought into trial, because oftentimes the father's attorney just has to assert that she's a lesbian, even without hard facts. And then it swings the burden of proving that she's a capable mother onto the mother, really. So she has this huge thing to overcome, the fact that she is a lesbian, if she is willing to admit that. Even if she doesn't care to admit it, it's there, and it does really shade the case against the mother drastically.
The homophobic society, which is reflected in the courts, has surrounding with it a number of myths once the lesbianism of the mother is asserted.
Like, what are those myths?
She won't provide a fit home because there will be an array of lovers coming in and out of the home. It's
promiscuity.
Promiscuity. It's not a stable relationship. Whereas almost every case that I am acquainted with the facts, they're not even looking at the realities of the home situation, which is in fact a very stable home relationship. Usually you have both women, their own children. If they're both custodian of children, you have a larger family unit. I mean, but they get into this instability, promiscuity aspect, that there will be sexual acts in the presence of the children.
Exhibitionism.
Because it's a lesbian home. Often with no real facts to support it, but with the court's attitude and society's attitude as it's reflected in the court saying that. And again, the mother is called on to defend herself and to prove that that is not happening. The kinds of assumptions that you just do not find in a heterosexual custody fight.
It seems that some of the most recent cases the people involved are very conservative. They're talking about a nuclear type family. They're not talking about communes and crazy wild lifestyles.
Absolutely not. The individuals involved would have nothing to do with that way of life, even if they had a preference, a choice in that. So oftentimes the case is that the mother is very active in community affairs. Maybe she's a professional woman, a teacher, a nurse, or whatever, and has started really a stable relationship with another woman. And this fact alone seems to cast a whole different light on the whole matter, so that she is up against proving that she is not some kind of wild, unstable person, just the mere fact that she's involved in a sexual relationship with another woman.
Well, we're going to continue this discussion next week, and we're going to be talking with two women from Texas, Mary Jo Risher and Ann Foreman, both lesbians, and Mary Jo is involved in a custody case. Ann has custody of her child, and they live together in a very conservative lifestyle. And they're real typical examples of the types of people that have been coming forward in these cases. And I was amazed, frankly.
Well, very often the woman is put in such a defensive position by the acts of the father, by calling her into court, and will be put in a position where she will have to come forward, perhaps not at the time at which she chose, to defend herself on the issues.
Well, it seems to me that in general, in many instances, our attitudes toward homosexuality are improving and loosening up somewhat. I mean, there are other disciplines, the American Psychiatric Association, many religious groups and so on are for gay rights. What's wrong with the legal system?
Well, we've had some steps in the right direction in some of the civil rights cases, where it's been held that various teaching licenses cannot be denied to someone who is homosexual because there is no rational connection between teaching and homosexuality and harm on pupils. I think in the custodial area, in the family area, the courts and society has taken a very protective role of preserving the heterosexual nuclear family, and they're fighting real hard on that one bastion. And I think through a lot of education, this may begin to change, but this will be one of the last attitudes.
Yes, I agree with that. One thing that we do see in the cases we read about and the ones we hear about is that if a woman is visible in her homosexual activity, such as she belongs to gay rights organizations, that is going to go against her in court. It's okay, I guess, if you're a lesbian and don't let it be known to very many people, but as long as you announce it or make a stand on it. This is frowned upon by the courts. So we've seen cases where gay activists have not received either custody or teaching positions when they were an issue. And I think this is wrong. This really infringes on her right to speak out on an issue if she wants. We see this more and more now with younger women that won't be bound by having to hide their lesbianism, and they think it's perfectly okay. And why should a court object? They have a wonderful relationship with their children, and why indeed should they not have custody of those children? And I think they're mystified and appalled by rulings against them, saying, no, if you're this kind of person or if you're living with another woman in a sexual relationship, we just will not allow you to have your own children. It seems grossly unfair to me representing these clients, because it really distinguishes between maybe a woman who is heterosexual in orientation. She can have all the freedom she wants in her private life to see whomever she chooses without any restriction on her. And there's no question that she can have those kids.
Well, as attorneys, how do you protect your clients from these biases, whether it be the judge or, in Mary Jo and Ann's case, a jury, which was unusual, but how do you do that?
I think the beginning protection is to try as much as practicable to stay out of court, to truly protect the best interests of the children and the parents. If the parents go to war completely in this custody arena, they will never deal with one another again, and they do have the same children, and they should. And the woman, at least on the East Coast in New York State, runs a great risk of losing custody completely. So my perspective is to, number one, prepare very thoroughly, to perhaps convince an adversary, the father's lawyer, that we should work with some independent experts and see what kinds of evaluations they have of the family unit and what's best. Perhaps to try to work out some kinds of joint custody that might give both parents a good deal of input with the children so that neither feels that they are kept out of custody. I mean, to try to be truly innovative and protective of client prior to having to go to court. To me, court is the last resort.
Yeah, I think that's very good advice. In fact, the judges themselves don't like these cases. These are the last thing they want to decide, who should have the children, the father or the mother.
Well, what if you do go to court? And how would you protect your client, say, against the bias of a judge?
Well, first of all, by competently establishing that she is, in fact, a very good, loving, competent guardian, custodian, that is her proper role, making certain that there's nothing that's going to be brought up adverse that can't be explained or countered by bringing in very competent expert witnesses. You end up with a number of psychiatrists, child psychiatrists, sociologists, anthropologists. You have a variety. One case I tried, we brought several members of various denominations in to prove a community attitude about homosexuality. Just to show a variety of attitudes, to show her life has been one of being a good parent.
Yes, I agree. I think the focus is really on the mother's relationship with the child. What would it be in the best interest of that child to be taken from the mother's custody if the child is grown up in the home of the mother?
You mean ideally that's the issue?
Yeah, that should be paramount. Right. I agree. Your implication is that that isn't always. And sometimes we get a feeling as attorneys in the courtroom scene that the judge is possibly protecting the values of the community. Maybe that's overriding the heterosexual orientation versus the homosexual. Perhaps that's an overriding concern with the judge rather than what's in the best interest of the child.
Well, would you ever advise a client not to disclose her sexual preference?
Yes, sometimes clients come to you before they've really decided what action to take, and in a counseling situation, they ask many questions. Should I let my husband know I'm in a lesbian relationship? Should I leave my husband? What should I do? You know, should I live with my lover? And as a rule of thumb, of course each situation is different, but as a rule of thumb you have to say, well, you keep as low a profile as possible. Don't disclose it unless you just for your own personal and political reasons possibly have to. And don't admit to anything, and try to avoid it at all costs.
Margo, that would also be the type of advice you would give a client in a heterosexual relationship.
Right.
You know, be discreet. What I also do is I have Xerox copies of the two recent Supreme Court decisions in New York State, one in Brooklyn and one in Syracuse, one of them quite lengthy. And I give clients that to read and to take home, and I say, okay, these are the risks. In both cases, the mother does not have custody. These are the risks. Now, I will cite specific reasons in each case why. There are some very special factors, but I think we have an obligation to educate our clients that it can be a very difficult battle.
I think if I knew I were going to be in that kind of situation, the first thing that I would be very afraid of would be finding the proper lawyer. I would think you could just let yourself in for an awful lot of trouble, not getting a lawyer who would be sympathetic or who would fight for you.
Yeah. So one problem that many women have is where to go to find the proper attorney.
Is there a way? Is there a way to tell?
I think a woman can go to maybe local groups, women's groups in her area, ask their advice, who they would refer, find out who has got a good reputation as a trial attorney in a domestic relations action, and also, upon seeing that attorney, discuss with her attorney what his or her feelings are about a lesbian case.
And very important that the woman, when trying to find her prospective attorney, recognize that it is a confidential situation when she is talking with any prospective attorney, and perhaps see more than one, but don't hide relevant factors, because there's no way that you can just feel someone out. You're going to have to recognize that is confidential. That attorney cannot at any point reveal what happens between the attorney and the client, but that this must be made aware.
Yeah, she should find someone she's really comfortable with, who she feels will be comfortable with this kind of thing.
Do you think that precludes having a male attorney?
Not necessarily.
I think it's a lot easier with a woman.
I knew there was going to be a little. But you would advise just really to get someone you can get along with and that you feel comfortable with.
Right. The clients seem to have a pretty good idea of whether or not the attorney's comfortable himself or herself with the subject matter, because I've had them come to me and say, well, my last attorney really couldn't look me in the eye after I told him this was the situation, or whatever the circumstances were.
Seems to me there's another issue involved here, and that is it really parents' rights or children's rights that are involved here?
That's a good question, isn't it?
I think we'd like it to be children's rights predominantly. However, the court, in our advocacy system, we end up with an attorney for the father, an attorney for the mother, and I know in New York State I have often made a request to have an independent attorney appointed for the child or children, and I always get turned down. And in New York State, there's been no way to get them an advocate, someone who truly looks after their interests, because the parents are warring with one another. The children are caught in the middle, oftentimes called into judges' chambers and asked their preference, which must be a very guilt-provoking question for a very young child to be asked, who would you rather go with? What would you rather do? They get interviewed by psychiatrists and sociologists and social workers and everything. And no one legally is looking after their rights other than the court. That's my
It
feeling.
sounds to me, you know, from some of the descriptions I've heard, like a real horror show for kids to go through. I mean, how can they make that kind of determination on their own? How can they accept that responsibility? What are some responses from children that you've run into from cases that you've had or heard about?
Well, let me first say that not every child is called upon to make a decision. In California, certainly a lot of judges will not ask
Well,
them or
but
take
whether
them
they are
into
in the legal
chambers.
situation or not, they are in the private situation, are they not?
Sometimes they keep out of it. They say, I love mommy and daddy both. I don't want to express a preference if they're old enough to understand and know to do that.
I've seen the real terrible tears on children. I've known one case where the oldest, who was about 8 at that time, recounted that his father had told him, if you say you want to go with mommy, you'll never see me, the father, again. I think that's horrible for a
Sure,
child to
right.
go through that. A child who loves both parents.
This is true in any custody case that goes to the court level, really, that can't be resolved outside of court. But I think what comes up in lesbian mother cases is the fact that she's a lesbian, possibly in a relationship, and this is brought to the front, and everybody's talking about it, and it really impresses the children. That what is this thing? You know, I don't quite fully understand what it means that mother's a lesbian. And had it been not played up as much as these cases seem to be by the time they get to court, I think this could be handled with a lot more ease and adult understanding, really, saying that she could handle it better with
What
the kids.
determines whether the child testifies or not?
In California, the child doesn't testify.
Oh, it's an across-the-board thing?
Well, I've never heard of putting a child on the stand as such. Children are sometimes taken into chambers,
Oh.
and the judge
Which is
will sit
private.
down with them in a fatherly way.
That's really what I meant. I'm not a lawyer.
Okay. I mean, they don't go through the trauma of being in a courtroom. In fact, sometimes they will talk to the judge alone, and the parents won't know what the child said to the judge.
Ordinarily in New York, they talk with the judge alone if they're about 7 or 8 years old and up, and neither parents nor attorneys are in the room with the judge.
Right.
So they just have their little discussion, and the judge ordinarily doesn't reveal what's happened during that discussion.
Let- Let's talk briefly, because we only have very few more minutes, about the atmosphere in the court, the kinds of questions that are asked of the lesbian mother and possibly her lover and other people involved.
As far as I've seen and heard, they're some of the most embarrassing, difficult questions, and custody cases are hard enough, but these are doubly, triply charged. I mean, they're embarrassing questions often asked of the mother as to specifics of her sexual behavior outside the presence of the children, but the judge just wants to know, or the husband's lawyer wants to know details of sexuality, which are terribly embarrassing. I've had witnesses who have testified as former employers just about the employment relationship. At the end of that, they're asked by somebody in the courtroom, "Are you a lesbian?" Questions that are just uncalled for.
I think this brings up what we are doing when we go to family court or in any dissolution proceeding. The judge does have wide discretion to hear a lot of evidence. Sometimes the rules of evidence are waived, strictly speaking. So he can really inquire into the situation of the couple and the family and ask these very embarrassing, very personal questions and feel justified in doing so. This also means that in California, for instance, it has to be decided in favor of the mother at the trial level because it seldom is overturned on appeal. This is due to the discretion that the courts do give the judges, thinking, well, he is there, he has heard everything, he has talked to the children in chambers, we don't have a record of that, so therefore we don't want to overturn the decision on appeal based on his factual survey of the information.
And also, it often takes so long for the appeal to be heard. By that time, a year or two have gone by, and the appeals court says, well, we don't want to change things once more. The children are already there.
One of the things that Mary Jo Risher, who will be on the show next week, has said is that she will take her case all the way to the Supreme Court if necessary. Now, when I told you that earlier, you had some negative reaction to that.
Well, I think in her instance it is good that she is doing that. Sometimes clients will come to me and say, I have a very good case, I'm a lesbian mother, I'm going to admit it, and I want custody of my children and live with my lover. And I would discourage them to taking that to the highest court if it meant jeopardizing custody of the children, because it's just too hard to get that. In Mary Jo's case, I understand she did lose custody of her son, and she has really nothing to lose, and it would be a very good thing to get some of these constitutional issues aired. There are issues of rights of privacy.
Can you explain them as you listen? We only have 1 minute.
Oh.
You have a right to privacy, which is part of due process. Privacy in between consenting adults, and that their relationship is being infringed on. You have First Amendment, right to expression,
and
association, and imposition of religious views through our society that are against homosexual parents.
And equal protection.
And equal protection of the law. In other words, heterosexual parents are guaranteed certain rights which homosexual parents are not per se given.
Are you both hopeful about the situation, that is going to improve? That
We'll keep on struggling.
Yes, I am. Yeah, thanks to the women's movement largely, because women are being out front about this now in litigating it, and it should be heard. They should have equal protection with other women.
Are you both going to continue to work with lesbian mothers, you think?
Oh, sure.
As long as I'm asked to, sure.
Right.
Thank you both very much for being
You
here.
bet, Sandy.
Thank you for watching, and good night.
This program was produced by WNED-TV, which is solely responsible for its content. Major funding was provided by public television stations. Additional support was provided by unrestricted general program grants from the Corporation for Public Broadcasting and the Ford Foundation.